Meet John. John is a biomedical researcher who has come up with an idea for a new product that can treat a particular disease, addressing a currently unmet medical need. John realizes that at this stage, he needs to keep his idea secret. Therefore, and before discussing it with his colleagues, he arranges that they all sign a confidentiality agreement. After the meeting with his colleagues, John is convinced that it is worth pursuing his idea and developing the product. John also understands that potential investors will be more interested in investing in the development of his product if he obtains the appropriate patents. So John contacts a patent attorney who performs an initial search for what we call prior art, meaning any previous information regarding a similar product available in the public domain. The attorney's search reveals no prior art, and John and his patent attorney write a patent application describing the invention and its claims. The next step is to file the patent application, generally in the form of a so-called priority application. With a priority application, the filing date is known as the priority date. This date is important because, for 1 full year, all countries that signed the Paris Convention for the Protection of Industrial Property will apply this date to all patent applications that John will file for his product in these countries. The 1-year period following the priority date is called the priority year, and it eliminates the need for John to file the same patent application in all target countries on the same day. More importantly, any application filed by John within the priority year is treated as if it were filed on the original priority date. Obtaining a priority date as early as possible is important because the application will be judged only based on information that was available to the public before the priority date. Virtually all applicants use this priority system because it has a few clear advantages. First, the applicant has a full year to decide whether patent protection is actually worthwhile from a commercial perspective, and where. Secondly, it gives the applicant a year to obtain financing for the subsequent filing steps. By the end of the priority year, the patent application must be finalized. In order to move forward with the application process, the final text must meet all criteria for patentability. Specifically, the invention should be novel, inventive, and suitable for industrial application. At this time, John must also decide in which countries he will likely need protection for his invention and which route he will use to file. Here, John has several options. He can choose to file a national application, a so-called regional application that covers 1 or more countries, an international application that covers all countries that signed the Patent Cooperation Treaty, or a combination of these 3 options. Let's take a closer look at these 3 options. To obtain a patent in 1 or more countries, the quickest route is to use the national route and file directly with patent offices in those countries before the priority year has expired. For instance, if John files his priority patent in the United States on January 31st, 2020, he can then file a similar application in various other countries through January 30th, 2021. Unfortunately, each national patent office can have its own requirements. For example, they each charge their own filing and examination fees, and they may require that the application be written in the local language, requiring an expensive translation. Thus, this route can be cumbersome for John, who may wish to protect his invention in several countries, but has limited financial resources. To overcome many of these issues, John may choose to file a regional application, which covers several countries in a specific geographic region via so-called regional agreements. The most well-known regional agreement is the European Patent Convention, or EPC. Under the EPC, a single patent application can be thoroughly searched and examined by the European Patent Office. If the necessary criteria for patentability are met, a European patent will be granted, then converted into a bundle of individual patents that provide protection in one or more member states covered by the EPC. If John wants to file his invention on a more global scale, he can choose to first file via the international route, which can serve as a springboard for the subsequent national or regional route. Under the Patent Cooperation Treaty, or PCT, a single patent application can designate one or several of the more than 150 countries that currently participate in this treaty. After the patent application is filed and the examination fees have been paid, it is thoroughly reviewed by a patent office examiner familiar with the technology described in the application. During this review process, the patent office examiner will search for any prior art that would defeat the patent's novelty or is otherwise relevant to the application. With the international route, an International Search Report, or ISR, as well as a written opinion, or WO, will be obtained within 18 months of the priority date. The ISR is essentially a list of documents marked with indications such as X, lack of novelty, or Y, lack of inventive step. It is then the applicant's responsibility to review the contents of these documents. The WO provides a preliminary, non-binding opinion regarding the invention's patentability. If the WO includes issues regarding patentability, John can still modify the claims in the application. If John desires, he can subsequently request an International Preliminary Examination, or IPE. If he makes this request, he will then receive an International Preliminary Examination Report, or IPER. If not, then the IPER will be identical to the WO. The IPER is a more detailed, but still preliminary, examination, providing comments regarding specific issues related to patentability. Once John has received the ISR, and if applicable, the IPER, the international application process is completed, and he must now begin the formal examination procedure via the national and/or regional route. This must be done within 30 months of the priority date. It's important to note here that no patents are actually granted at the end of the international route, as there is no such thing as an international patent. Even so, this route is commonly used because of several key advantages when this route is pursued in preparation of the national or regional route. First, the ISR and IPER will give John a clear indication of whether or not his patent is likely to be granted before incurring the costs associated with filing numerous national and/or regional applications. If the reports are not positive, the patent application can be abandoned. Second, all the formalities for administering and filing the patent applications in the multiple national and/or regional patent offices are taken care of and are therefore considerably simplified. Third, the ISR constitutes an important milestone that gives John a better idea of his invention's commercial value. Plus, the 30-month period helps John find additional investments. Fourth, the deadline for filing national and/or regional applications is extended to 30 months after the priority date. As you can see, John has several routes for obtaining a patent for his invention, and each route has both advantages and disadvantages with respect to costs, timing, and the process itself. There is one important aspect that applies to all three routes. The application and the examiner's reports are generally published no sooner than 18 months after the priority date. This gives John ample time to consider withdrawing the application based on the reports, allowing the application and the invention to remain confidential. Because there is no one-size-fits-all solution, these routes must be carefully considered and discussed thoroughly with an experienced patent attorney at an early stage. If you are interested to learn more on how to protect your new medicinal product, you may want to consider to take part in the Blended IP course of Paul Janssen Future Lab. Check our website to find the details of this course and the course dates.